The discovery process in simplest terms is the exchange of information. Whenever litigation is instituted, there is a process that we go through that we call discovery, which requires each side to disclose any and all relevant information to the other side. Contrary to what some people may think, you cannot conduct a trial or have a hearing by surprise, for lack of a better term. It means that you have to disclose any and all evidence that you would like to use in a courtroom to the other side, and the other side needs to disclose any and all information and or evidence that they would want to use in a courtroom, because in many states, including North Carolina, you cannot conduct a trial by surprise. And so in its most basic terms, it is simply the exchange of information. And while that may sound simple, it's actually a very complicated process, because when you say the exchange of information, it can be a large amount of information or it can be a relatively small amount of information. So it is a very technical process that is governed by very technical timelines and very technical rules of civil procedure. So it is a very important process, and it is a process that begins at the initiation of a case and then continues throughout the case. So it does become a very important process of any case that you would be involved in. It's necessary because you need to know what issues will or will not be presented at trial, not only on your side, but also from the opposing side. And so the opposing attorney will get an idea of what issues you intend to present to the court, but you also get an idea from the opposing side as to what issues they want to present to the court. So not only does the discovery process take place between the attorneys, but it could also involve the court, and the court can make decisions as to how that discovery process is going to take place. But it is absolutely necessary, and it is absolutely something that needs to take place before you ever walk into a courtroom. And as mentioned, it is a rather technical process, and it can be very involved, and it can take a fair amount of time depending upon how much information needs to be exchanged between the attorneys or between the parties. It works by sending a set of requests to the opposing attorney, and or the opposing attorney sending a set of requests to you. These requests can take different forms. One form is a deposition. A deposition is a situation where we as attorneys want to talk to witnesses or parties prior to walking into a courtroom because we want to gather certain information. And so we are required to follow the rules of civil procedure, schedule depositions, provide notice of depositions, and it is one way we can start to gather information before we walk into a courtroom. Another way to gather information is to send a document production request. And a document production request is really what it sounds like. It is a request to produce certain documents. And it can be anything from bank statements and credit card statements to investment accounts, to emails or text messages or pictures, and that in the arena of family law is typically what we are looking for in the discovery process or when we request documents. You can also conduct discovery through interrogatories, which is a set of specific questions that you prepare and send to the opposing side, and then the opposing side is then obligated to answer those questions. And another form of discovery is a request for admissions, where you create a set of statements that are forwarded to the other side, and then the other side is required to answer those questions under oath. But there are different forms of discovery. Not all of them need to be utilized at the same time. You can utilize some forms of discovery while not utilizing others, or you can use all of them, and that's why it can be a rather time-consuming and complex process, but it is very much a necessary process if you are to fully understand all of the issues that are going to be presented in any given case.